Is somebody threatening, harassing, or stalking you and you're wondering what you can do to protect yourself? I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today I'm going to explain how to file a restraining order in Connecticut Family Court. Now, first off, let's talk about who is eligible for a restraining order. You are eligible if a family member, and I'll talk a little bit more later about how a family member is defined by the court. That family member must be subjecting you to a continuous threat of present physical pain or physical injury, so they're threatening you harm, they're stalking you, or they are exerting coercive control over you. And I've talked a little bit more in a separate video, which is titled Jennifer's Law, and that video defines coercive control here in Connecticut. If you fulfill that definition of when a restraining order is appropriate, then you will first fill out an application for relief from abuse, which is a restraining order application. You can locate this form online by doing a Google search for JD-FM-137. You will first fill out the judicial district where you are filing the application, and that can be based on either where you live or where the other party lives. You will then fill out the address of the court. You can leave the docket number blank because your case will not yet be assigned a docket number until you file the restraining order application. You will then fill out the section below with all of your contact information, followed by all of the opposing parties' contact information. You will see terms like applicant and respondent. If you are filing the restraining order, you are the applicant, and the respondent is the person who you are filing the restraining order application against. You then have to fulfill one of the below definitions of a family member. If you can't check off any of these boxes, then you are not eligible for a restraining order. You could instead file a civil protective order, which is a similar application against somebody who is not a family member. So you're eligible if the person you are filing against is a spouse or someone you have a civil union with, someone you have cohabitated with as an intimate partner, a parent of your child, your parent, a person who is the parent of your child and you all live together, a person related by blood or marriage, a person you reside with, a caretaker, or a person you had a dating relationship with or currently have a dating relationship with. You then check off the box below if there are any other protective orders or restraining orders. A protective order is an order that is issued through criminal court, and a restraining order is an application in family court. If there is a history of protective order or restraining order with this person, then you'll fill out the docket number and the court location of that protective or restraining order. And then if there is a pending divorce or custody matter, then you'll fill out the docket number and court location of that matter. You will then fill out whether or not the person has any firearms and relevant information relating to those firearms. You will then move on to page 2, where again, you'll fill out your name, the respondent's name, leave docket number blank, and then you will fill out what you are asking the court to order for relief. You will almost always check the box that you don't want the respondent to assault, threaten, abuse, harass, follow, interfere with, or stalk you. If you don't want them to be anywhere near your home, then you check off the second box. If you don't want them to contact you in any manner, you check off the third box. If you want them to be able to return to your home once to retrieve belongings, then you check off this box. If you are residing with the opposing party and you are staying in the home, the court will almost always check off this box and grant that party the ability to come back to the house once to retrieve their belongings. But if you are planning on moving out of the house that you live in with the opposing party, then you check off the box that you want to be able to return to their house to retrieve your belongings that you need. You may want to check the box that the opposing parties stay 100 yards away from you. If you want the order to extend to your children because there has been inappropriate actions towards your children, then you check off box CT19. And again, you have to make sure you put all of the contact information for each of the children who you want to be protected by the restraining order. And if you have any animals that you want to be protected by the restraining order, you check off box CT31. You may also be asking that the court enter temporary child custody or visitation orders. And if you do, you fill out the section below. Again, you put all the contact information with the children. You check off how you want the visitation schedule to look, or if you don't want the opposing party to have any visitation, then you check off box CT22. And in paragraph 3, you can then ask for any other relief, and the court may or may not grant that relief. If you want a copy of the restraining order sent to the school that you attend, if you are in school, you can put your school's contact information. And if you want the restraining order sent to the school of your children, you can check off this box below and fill out the contact information for your children's school. And if you are asking for immediate relief, which most likely you are, you check off the box on paragraph 6. And finally, you will sign the form, but don't do so until you arrive at the court because it will have to be notarized. You will then have to fill out form JD-FM-138, and that is the affidavit that goes along with the restraining order application. On this, you will put your name, the opposing party's name. Again, you leave the docket number blank, and you will fill in exactly what happened that is leading you to file the restraining order. Make sure you put as much detail as possible about how the other party has assaulted you, threatened you, harassed you, etc. You will want to include specific incidents, and you will want to put the dates of those incidents, as the court will want to see that the behavior has been happening recently rather than far in the past. You check off if you want the court to issue temporary custody orders, or if you don't, then you can check off the box that you are not seeking any temporary custody orders. Again, you will wait until you are with the clerk to sign and date the form. If you are asking that the restraining order extend to any minor children, you will also have to fill out an affidavit concerning children, which is form JD-FM-164, and you will put all of the relevant information for the children, including where they have lived for the past 5 years, who they have lived with, etc. And finally, if you are asking for financial support once the restraining order goes into effect, you will fill out form JD-FM-233. Now, you're only eligible for financial support through a restraining order in one of two scenarios. So it must be that the other party is your spouse or somebody you have a civil union with, or they must be the parent of your child and you are all living together at the time that this restraining order was filed. You check off why you are seeking the relief. There may or may not be any existing orders in place, or you may check the box that an order is necessary to maintain your safety or the safety of dependent children, or an order is necessary to provide for your basic needs or the basic needs of dependent children. You will then check off boxes for the exact financial support you are looking for. And you can fill out section B, all of the boxes below, and these sections can be granted ex parte. So that means a judge can grant the relief immediately when you file the ex parte application. However, the sections in paragraph C below, they cannot be granted immediately upon the filing of the application. The judge cannot grant any of the relief in this section until after you have a hearing on the restraining order application. Now, once you have filled out all of these forms, you will take them to the clerk's office of the courthouse where you are filing the restraining order. There's no filing fee for a restraining order in Connecticut. The clerk will take the paperwork and they will bring the documents to a judge to review. Now, the judge will schedule the restraining order for a hearing within the 14 days following the submission of the application, and the judge may or may not grant immediate relief. So the judge can order things like a 100-yard stay away or no contact to go in place immediately. However, they also may not grant that immediate relief and instead schedule the matter for a hearing 14 days later to determine whether or not relief should be put in place. But again, in either scenario, there will be a hearing within 14 days at which you can request that the restraining order stay in place moving forward for up to 1 year. Once you receive the paperwork back from the clerk, you will then have to arrange for a marshal to serve the other party. In Connecticut, when there is a restraining order application, there is no fee for the marshal. The clerk will put you in contact with a marshal who will arrange for the paperwork to be served at no charge. You just have to make sure you get a return of service back from the marshal so that you can submit that document to the court to establish that you did in fact serve the other party and they have notice of the restraining order application. You'll want to make sure, of course, that you show up for the hearing date. And what will happen on that hearing date is you will first meet with family relations, which is a neutral mediator who works at the courthouse. And you will work with that person to see if you can reach an agreement with the opposing party as to whether or not a restraining order will stay in place. And if so, what the terms of that restraining order will be and how long the restraining order will stay in effect. Hopefully you will reach an agreement with the opposing party. However, if you don't reach an agreement, then you'll have to have a hearing in front of a judge where you will present evidence. Make sure you have documentation of text messages, phone calls, etc., of what the threatening or harassing behavior is. So you'll present that evidence and testimony. The opposing party will also have the opportunity to present their own evidence and testimony, and the judge will make a decision, and that decision is final. So those are the basics on how to file a restraining order here in Connecticut. As usual, if you have any additional questions, you can contact our office. And if you're looking for representation in a restraining order matter here in Connecticut, we would invite you to contact our office as well.